Officer, the issue of independence cannot be suppressed. It must be resolved democratically. And that must be through a process that is above reproach and commands confidence. That is why I am setting out today the actions the Scottish Government and the Lord Advocate will take in the absence of a Section 30 order to secure Scotland's right to choose. My determination is to secure a process that allows the people of Scotland, whether yes, no or yet to be decided, to express their views in a legal constitutional referendum so that the majority view can be established fairly and democratic. The steps I am setting out today seek to achieve that. They are grounded in and demonstrate this Government's respect for the principles of rule of law and democracy. Indeed, these core principles, respect for the rule of law and respect for democracy, underpin everything I say today. Respect for the rule of law means that a referendum must be lawful. That, for me, is a matter of principle, but it is also a matter of practical reality. An unlawful referendum would not be deliverable. Even if it was, it would lack effect. The outcome would not be recognised by the international community. Bluntly, it would not lead to Scotland becoming independent. Presiding Officer, it is axiomatic that a referendum must be lawful. But my deliberations in recent times have led me to this further conclusion. The lawfulness or otherwise of the referendum must be established as a matter of fact, not just opinion. Otherwise, as we have seen again in recent days, opposition parties will just keep casting doubt on the legitimacy of the process so that they can avoid the substantive debate on independence which Scotland deserves, but they so clearly fear. That is not in the country's best interests. Let me turn then to the detail of the steps we will now take to secure that objective of an indisputably lawful referendum, and then ensure that from today we can focus on the substance of why Scotland should be independent. Presiding Officer, I can announce, first of all, that the Scottish Government is today publishing the Scottish Independence Referendum Bill. I will draw attention in particular to three key provisions of this bill. Firstly, the purpose of the referendum, as set out in Section 1, is to ascertain the views of the people of Scotland on whether or not Scotland should be an independent country. In common with the 2014 referendum, indeed in common with the Brexit referendum and the referendum to establish this Parliament, the independence referendum proposed in the bill will be consultative, not self-executing, just as in 2014 and recognised explicitly in the 2013 White Paper. A majority yes vote in this referendum will not in and of itself make Scotland independent. For Scotland to become independent following a yes vote, legislation would have to be passed by the UK and Scottish Parliaments. Now, there has been much commentary in recent days to the effect that a consultative referendum would not have the same status as the vote in 2014. That is simply wrong, factually and legally. Let me be clear. The status of the referendum proposed in this bill is exactly the same as the referendums of 1997, 2014 and 2016. The next provision of the bill I wish to draw attention to relates to the question to be asked in the referendum. The bill states that the question on the ballot paper should be, just as it was in 2014, should Scotland be an independent country? Finally, Presiding Officer, the bill includes the proposed date on which the referendum should be held. In line with the Government's clear mandate, this is a date within the first half of this term of Parliament. Presiding Officer, I can announce that the Scottish Government is proposing that the independence referendum be held on the 19th of October 2023. These are...
Thank you.